All right. So, what did we learn yesterday? The last class, what we did, we had section 53. And in section 53, we tried to understand the discount is prohibited, and I also tried to explain the logic why discount is prohibited under section 53. If guys discount is allowed, there are possibilities that top level management may go for the cornering the shares and they can dilute the powers to center. Possible or not? Okay. So no government can want it for the sake of corporate governance. So I appreciate that. Other things what we tried to understand, it was about the meaning of discount. There are a lot of, I would say, contradiction is happening while we study less than face value or fair market value, less consideration what you're receiving. What should be the correct interpretation? So I try to just put my justifications. Unfortunately, the word discount is not defined in the act. That's what something unfortunate, I would say. Something unfortunate. And there are two exceptions we tried to learn. The first one is sweat equity shares. It is exception. What is nothing but our next section to learn, and that is, I would say, section 54. And one more we tried that if there's a debt, debt restructuring as per the RBI guidelines, debt restructuring, you know that the creditors are getting converted to equity shares and everything is happening according to the RBI regulations, then it is quite possible that creditors may accept your shares at a discount, but fine, it is allowed. But anyhow, if company is getting survived, that is more important than the other things, right? All right, now we are moving towards section 54. And section 54 talks about issue of sweat equity shares. And these all are the provisions along with the rules we have to understand. Look at guys, you may find like, okay, this provision is just how many? Subsection number 1 and subsection number 2. Nothing more to do. It is not like that. Look at this part, as may be prescribed. In fact, I say that Companies Act 2013 is made of the two important components. The first one is the provisions itself, that is nothing but the act itself. And the second thing is the rules what are notified by the central government. So when I say Companies Act 2013, it doesn't mean only the provisions along with that. For example, you see, it is mentioned under section 139, and 139 talks about, I would say, appointment of auditor. Look at it. Appointment of auditor. So when you go over here, that appointment of auditor, it is written over here that fine, auditor will be appointed according to this section, according to that section. But how he will be appointed? What are the rules regarding appointment? Which form the company or the auditor need to file to the ROC? Where are those rules? So I would say they are written over here as may be prescribed. As may be prescribed. So look, whenever you want to understand the rules regarding that particular provision, I always insist the students to click on this. And as soon as you click, look at it, some more contents are coming out. Some more contents are coming out. And these contents are also equally important while we study what? The Companies Act. Okay? Okay, let me go back to my section 54. So, section 54 is nothing but the sweat equity shares here. Okay, before I go with the explanation, let's understand that there is always confusion between the two fundamentals in the Companies Act. The first one is sweat equity shares, and the second is employees stock option. Always there is, because yes, in my career I have received these kinds of queries from the students side, that what is the fundamental difference between these two, because sweat equity shares are getting offered to the employees and employees stock option is also getting offered to the employee. And if you are the commerce student, I think all of you must have heard about these two concepts. What is the difference क्या है इन दोनों में? चलो, if in CA Inter the same question I do ask for the 6 marks, because I have observed many students are understanding that these two are same. Okay, so in the sweat equity shares, you compulsorily have to buy this. To the employees only. That's what you are trying to say. That is really. Do you really think that just for this tiny difference, the law will dedicate this separate section for that? Okay, this within this much time frame you have to. But again, I'm telling you, fine. The same things you can provide in the sweat equity shares also, that you have this much time frame within which you have to accept. Otherwise, you will not give. Ultimately, these are discounted shares. Market price is 250, but I'm offering for the 100. But whether you need to pay 100 or not, who will decide that? Okay. But okay, fine. Do you know whatever you are saying, that is nothing but I would say technical points. हाँ ठीक है, इसमें ये नंबर होगा, उसमें इतने दिन हो गए, समथिंग लाइक दैट. ऑब्जेक्ट्स क्या है, लॉजिक क्या है इन दोनों के बीच में? Okay, that's what we have to understand. Okay, so before I go to the provisions of the section 54, let's understand the fundamental difference between sweat equity shares and employee stock option. So look at the first one is the sweat equity shares. First, it is defined under section 54, whereas employee stock option is defined under section 62. Under section 62, subsection 1 and clause B in the Companies Act. Okay, now it is very interesting to know, look at here where the sweat equity shares is located. So just come down to here, further issue of the share capital. You will tell me, whenever company is issuing the equity shares to the employees, isn't it something what is in addition to the existing paid up capital? So isn't it the further issue? Yeah. Look, further issue can be classified into these three types. First, you have to issue to the existing shareholders. You are issuing to the employees, or you are issuing to the outsiders. Neither to existing one, nor to employees, but directly outsiders, public. So further issue can be categorized into these three. Recently, we have just observed that Adani Enterprises Limited withdrew its FPO back, further public offer. So if I ask you one simple question, that as being the listed company, which provisions of the Companies Act is applicable? So my answer to that question is section 62, and the point number 3 will be applicable. It is not offered to the existing shareholders. It was not offered to the employees, but it was open for anyone who wants to come. 20,000 crores. And sometimes in exam, they do ask a question that if the company wants to issue the shares to outsiders, what is the procedure? So there are three questions possible out of further issue of the share capital. The first one is, you are offering to existing, you are offering to the employees, and you are offering to the outsiders, that means public. These three kinds of explanations are possible here. Got the point? Three kinds of explanations are possible. Fine, but right now I do not want to touch the first and third. Let's understand that what is written under this. So look at, there are so many subsections. First of all, subsection 1, after then subsection 2, then 3 and the 4. But all these three are provided in subsection 1, right? So look at subsection 1A. Subsection 1A, it is about the right issue, because whenever you are issuing the shares to existing shareholders, it becomes the right issue. I think you know that, right? So look at the language, what is written to the person who are the holders of equity shares. So whenever you're issuing to someone who are holder of the equity shares, right issue. चलो यहाँ तक समझ में आई बात? When you come down to here, B point, it is written to employees. So as soon as guys the word employees comes to the picture, it is nothing but what? ESOP. And third one, what it says? It is said that not those persons who are included in A and B. So who are included in A and B? Existing and employees. So if you want to offer to someone who are not included in A and B, that means who left over? Other than members, or I would say outsiders, public. Either you are going by private placement or you are going by public offer, that is your call. But whenever you are issuing to outsiders, subsection or clause C will be applicable. Am I clear? Okay, now I have already started this discussion. So before I go to the fundamental to section 54, let's throw some lights on 62. So in my chronological order, whenever section 62 comes to the order, I will not discuss now at that point of time. Let me discuss over here. Do you know an interesting fact about section 62? Okay, let me just take the question like this. Suppose there is a company which decides that we want to issue the shares to public. To public. So let me tell you what are the facts. Company didn't offer to the existing shareholders and directly went to where? To the public and told that okay fine, as the sections 62 subsection 1 and clause C allows me to go to the outsiders. I'm using that power as given under section 62 subsection 1 clause C, and I want to get the money from the outsiders. I don't want to give the first chance to the existing one. मुझे नहीं देना चांस है और डायरेक्टली पब्लिक में चली गई. And some of the existing equity shareholders got annoyed by this. Because as being the existing shareholders, why they have not offered to them first? Why they went to the outsiders first? And they filed the complaint to the National Company Law Tribunal. My simple question is, the actions of the company offering the shares directly to the outsiders, is it valid according to section 62? That is a simple question. So look, what most of the students are thinking, अरे भाई, when power is given, then what's the wrong in that? सीधी सी बात है. 62 पढ़ो, subsection 1 सी में सीधा लिखा है that you can go where? To outsiders. गलत क्या है उसमें? So there is nothing wrong in that. देखो जिंदगी में एक बात ध्यान रखना, जब घरवाली घर में होती है और आप बाहर वाली को घर में लाना चाहते हो, तो बेटा क्या होगा अगर बिना पूछे लाए तो? एक सीधा सा लॉजिकल सवाल पूछ रहा हूं मैं आपसे. झगड़े होंगे, पंगे होंगे, पहला अधिकार किसका बनता है? घर वाली का. मेरी बात समझ रहे हो? और मैं ये नहीं कह रहा कि आप बाहर वाली को मत लाओ, भाई आपकी चॉइस है. अगर आपके कंट्री का कानून अलाउ कर रहा है तो आपकी मर्जी, लेकिन घर वाली को पूछ के लाओ तो जीवन आसान होगा. You may be, look, just by giving this example, I have given you the answer of more than 5 questions in the share capital. So whenever company is approaching to outsiders in the terms of the share issue and not giving the first priority to the existing one, then guys, law doesn't say that we won't allow. The one condition is you have to ask the existing one first. Now there are two types of consents what are categorized according to the general meeting chapter. Either you take the ordinary consent or you take the special consent. Ordinary consent can be taken by using what? Ordinary resolution. And special consent you have to take by special resolution. So let me tell you, my dear students, which kind of consent the law has provided. So answer is there in front of you. If you want to go to the persons if and only if it is authorized by special resolution. And you know, students, that whosoever are aggregated in the meeting, among them 75% of the people, if are voting in favor of, at least 75% of the people are voting in favor of that resolution, then and only then we can say that it is passed. So I'm not saying you cannot, but take the consent by passing what? Special resolution. Am I clear to all of you? One more also point is, you see, whenever you're offering these shares to the public, I firmly believe that it should not be less than fair market value. Do you agree with this? It should not be less than fair market value. Why? I strongly believe issue of the shares less than fair market value will create discount, which is nothing but prohibition under section 53. How would government and the law will come to know that you have issued not less than fair market value? Simple सी बात है. How would you prove as being the company that your shares are according to the fair market value? You have to give the valuation report. You have to give what? Valuation report duly signed by the authorized valuer. So guys, there are two conditions. If any company wants to issue shares to outsiders, the first condition is they need to pass the special resolution. Whenever you are issuing to those who are not mentioned in subclause A and B. But further it is mentioned that it must have to be determined by what? The price must have to be determined by the valuation report by a registered valuer subject to the compliance of the provisions of the law. If this question they are asking for the 3 or 5 marks, but these two conditions you must have to write in your exam. Again, come on, repeat with me. So guys, if I say outsiders or the public, if the company wants to go, let me just continue with the same example what I gave in the Adani Enterprises Limited. What do you think Mr. Gautam Adani as being the managing director of the board of the company? Can he dare to just bypass this provision? No, beta. So what he did before just going to the public, the first thing what they did was he passed what? Special resolution. I hope I'm clear to all of you. And along with that, his shares are supported by valuation report. These two conditions are there. No. Wait. Before I go, but my question is still unanswered. याद आया मैंने question पूछी थी. Company directly offered to whom? Directly offered to whom? Public. And existing shareholders raised the objection on that whether this objection was valid or not valid. Answer to that question is that objection was perfectly valid. Law clearly says, bhai, first of all take the consent and then you go. Then you go. So ultimately you tell me, Vacha, what principle you have tried to understand out of this entire example and explanation which is not provided or not discussed yet in the classroom. Try to read something what I have not spoken. बताओ इससे क्या पता चलता है? नहीं वो तो लिखा हुआ है भाई, वो तो बता दिया. कुछ ऐसा जो मैंने अभी तक बोला नहीं है. ऐसा थोड़ी है, नए आने वाले वो भी तो ओनर बनेंगे ना भाई. देखो, the principle what I have not spoken, actually it is there. Whenever you are issuing the shares, compulsorily you have to issue. Listen to my words. Compulsorily you have to issue these securities, these shares first to the existing shareholders. Make sense or not? Listen to my words. Compulsorily. And if you want to go to outsiders, take the consent and then go. So if you have not taken the consent and you have not offered to the existing one first, but you have offered to the outsiders first, it is the clear-cut violation of the section 62, subsection 1 and clause A. In fact, my argument I can prove by reading the text of the law also. आप जानते हो बेटा, ये जितना भी ये आप टेक्स्ट पढ़ रहे हो, ये पार्लियामेंट्री लैंग्वेज है। पार्लियामेंट्री समझ रहे हो, इसको बैर एक्ट बोलते हैं। These are exactly the same words what were written in the bill, which are passed in Rajya Sabha and Lok Sabha, and which is exactly the same text, same words, which is signed by the President of India. तो यहाँ पे गलती होने के chances नहीं है. Perhaps when I give the material or any other faculty gives the material, there are high chances that some words may be here and there. But यहाँ पे जो लिखा है वो सत्य है. क्या मेरी बात समझ में आई? So let's go to here section 62 subsection 1. क्या लिखा है? Where at any time a company having a share capital proposed to increase its subscribed capital by the issue of the further shares, such shares shall be offered. Okay, let me just test your English grammar knowledge. Instead of shall, क्या होगा अगर may लिखा होता तो? May be offered. Interpretation will change or not change. I'm asking you simple question. Shall और may में फर्क क्या है? If it is may, it is optional. करना हो तो करो वरना मत करो भाई. But whenever the word shall is written, then कोई option नहीं है. It's compulsory that you have to issue to the persons who at the date of the offer are the holders of equity shares of the company in proportion as nearly as the circumstances admit to the paid up share capital on those shares by sending a letter of offer subject to the following conditions. अब conditions ठीक है वो काफी easy होने वाली है because it is like how much time you should give for accepting this. How much time you want to give the 7 days, 15 days, 13 days. तो वो पूरी चीजें वहां पे लिखी हुई है. So by reading this all the provisions हमने क्या प्रूव किया क्लास में? We have proved guys first right to equity shareholders का बनता है. Not only sorry preference shareholders are not included here. First right तो always किसका बनता है? Equity. चलो ये दो बातें क्लियर हो गई. कंपलसरी है वॉलंटरी है? दैट इज व्हाई गाइस ये कहा जाता है राइट इश्यू. डिड यू ऑब्जर्व वन थिंग? द वर्ड राइट इज नॉट मेंशन्ड इन एंटायर प्रोविजन. कहां लिखा है राइट वर्ड? वही तो उस जिसने भी पहली बार अकाउंट्स की किताब लिखी होगी उसने इस प्रोविजन को किस नाम से हेड दिया? बट आई वांट टू टेल यू द वर्ड राइट इश्यू इज नॉट द ऑफिशियल टर्म. बट एज इट इज इन द प्रैक्टिस नाउ वी हैव टू एक्सेप्ट इट. Pardon? Further issue the share capital to the existing equity shareholders. बट वो कुछ 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 ज्यादा नहीं हो जाएगा लंबा सा. तो अगर तेरे को ऑफिशियल देखना है तो ये रहा देख. I'm telling you simple thing. देखो I want you to realize that now this is the time where you have to clear your thought process. And please, I also want you that as far as the law is concerned, don't try to believe anything what is not mentioned in the law. Law means what? Either written in the text of the law. If some assumptions what you are taking, either they are supported by the High Court's judgment, Tribunal's judgment, Supreme Court's judgment, or ROC itself has clarified by way of issuing the notifications or the circular. इसके अलावा अगर आप कुछ भी लेते हो तो mere assumptions है. So your point is the right issue is issued at a discount. ये आप कहना चाहते हो? देखो वही चीज, अकाउंट कानून नहीं है. अकाउंट्स कानून नहीं है. अकाउंटिंग इज डन बेस्ड ऑन द प्रैक्टिस. और जानते हो अगर लॉ चेंज हुआ ना बेटा तो अकाउंटिंग ट्रीटमेंट भी चेंज होती है. व्हाट इफ गाइस लॉ चेंज्ड बट ICA like body didn't change the sums? तो लॉफुल वाइज ट्रीटमेंट गलत हो सकती है लेकिन अकाउंटिंग सब्जेक्ट वाइज ट्रीटमेंट तो सही है. आर यू गेटिंग माय पॉइंट? So until and unless somebody challenges this, they don't rectify. तो तो मुझे एक सीधी सी बात बताओ भाई, फर्स्ट ऑफ ऑल दिस इज व्हाट ओनली द प्रोविजन अबाउट द राइट इश्यू. आई एम टाइपिंग द वर्ड डिस्काउंट ओवर हियर. लुक एट. अरे भाई आजा. डिस्काउंट. ओके. Discount word in the entire paragraph I can see just under section 53, one out of one. Where but if you see the 62, right now we are at which page? 62 में आपको discount word ही नहीं मिलने वाला मेरे भाई. And other thing, assume I just approve your accounting statement, you go for the discount right issue. Right, section 53 allows to issue the shares at discount only under these two circumstances. 54 sweat equity shares, second is debt restructuring. तो अगर आप ये करोगे 53 का वायोलेशन हुआ या नहीं हुआ, तो जब कानून अलाउ नहीं करता तो आप कैसे जा सकते हो? मेरी इतनी आर्ग्यूमेंट है, प्रूव मी रॉन्ग. गलत साबित करो मुझे. और दूसरी बात, अकाउंट बड़ा या लॉ बड़ा? देखो ये कोई सब्जेक्ट की बात नहीं है भाई, ठीक है. सुनील सर को बोलना मत. मैं ये कहता हूं, इफ वन ट्रीटमेंट इज स्पेसिफाइड बाय द लॉ, other treatment is done in the accounting which is against the law. Are you getting me? I can say it's a violation. It is the violation. It is the violation. I'm saying that market price हमको लेनी ही नहीं है भाई, fair market value लेनी है. करोगे तो डिस्काउंट आएगा. Unfortunately, these things needs to be addressed in the law. Up to what extent margin, and do you know that's what I'm saying. Discount word भाई उनको define करना चाहिए ना. Stock market is not the fair. मैं ये नहीं कहूँगा, वो तो driven by the market forces है. मैंने कल ही क्लास में बोला था, is it possible to have the words like overpriced stocks? तो ओवरप्राइस का मतलब क्या हुआ? You confirm that these stocks do not deserve this much price, but just because the hype in the market and the demand, it went up. It's called, I would say, fair market value is the natural price. And I want to tell you, no matter like, in fact, the SEBI doesn't have control over it. Yes, in the stock market, artificial prices do run. I have to admit it. I have to admit it. Have you observed that some companies really do not deserve to go so far, but still, oh my God, they're touching the heights of sky, yaar. पता नहीं चलता कि कैसे आगे बढ़ गया. But fine, I don't want to go in that. My main point is fundamentals of this section 62, 1A and 1C is clear in everyone's mind. बोलो भाई, समझ में आ गया बात? Now बात है, what are the rules? The rules, I would like to tell you that board meeting will be called up. Board of directors will pass the board resolution that we want to offer to the existing shareholders. First, and then they will prepare the scheme. Scheme means if you are holding, suppose, 10 shares, in what proportion I should give you the right issue. 10 is to 2, 10 is to 3, something like that. If it is 10 is to 3, then if you are holding 10 shares, the company will give you 3 right shares. Now your doubt is, can I issue a discount? My answer to that question is, आप नहीं कर सकते. So ये section 62 है ना, it is just a game of priorities. It's a game of priorities. You are just favored by giving the first priority over the outsiders. If I am TCS Limited, my performance is damn good. And in fact, you also know that भाई इसके shares आए तो बहुत पैसा मिलेगा फ्यूचर में. LIC का IPO देखा भाई, मतलब कितना सब्सक्राइब हुआ था. पेटीएम का आया तो कितना सब्सक्राइब, हाँ बाद में डूब गया वो अलग बात है. बट लोगों को तो एक्सपेक्टेशन होती है. सो पीपल आर इन द क्यू टू गेट इट. Everybody is praying that, hey Bhagwan, please give me the first priority. Please Bhagwan, my share should get accepted. And that's why sometimes they are, applying in the multiple names. Sometimes by using the fake names. And that is why we have to introduce section 38. If you are impersonating someone or applying to the company shares in the fictitious name, पनिशमेंट लगेगी। ये पढ़ा था 38 में, याद करो। क्योंकि लोग अब कुछ भी कॉम्बिनेशन डाल के डालते हैं, बिकॉज मोर एप्लीकेशन मोर चांसेस टू गेट सिलेक्टेड। सो भाई हाँ वो चलेगा, क्योंकि वो जेन्यून है, वो जेन्यून का कोई इशू नहीं है। बच्चों के नाम पे कर दो, वाइफ के नाम पे कर दो। लेकिन चिराग अखानी पे किया, फिर अखानी चिराग पे भी किया, चिराग ठक्कर भी किया, चिराग लोहाना भी किया, चिराग रघुवंशी भी किया। आप समझ रहे हो? चिराग थॉमस भी कर दिया, चिराग राजानी भी कर दिया, चिराग अमलानी भी कर दिया, बस एक चिराग तो एक्सेप्ट होगा ही होगा। ऐसे थोड़ी चलता है भाई। 38 मना कर रहा है, नहीं कर सकते आप। एंड वट एवर मनी यू पेड, इट वुड बी कंसिडर्ड एज पेड बाय नो वन। और पैसे सेंट्रल गवर्नमेंट लेके चली जाएगी, पता है आपको। ठीक है, उसमें मेरे को नहीं जाना। आई एम टेलिंग यू, आप डिस्काउंट नहीं दे सकते। So that means whosoever are offered existing equity shareholders, they must have to pay the full price according to the valuation report. So guys, it is not a favor in terms of any less prices. It is just a favor in the terms of priority. Are you getting me? So I'm telling you all these subsections what you are looking over here, all this just set the priority. If I talk about the employees, so employees would be given the priority to get the shares of the company, even if in the market the people are having the huge competition to get the shares. I'm putting the hold on them. Nahi, you are my employees, my people. I want to give you the first priority. You want to accept it. ये फिलोसॉफी चल रहा है। 62 समझ में आया आप लोगों को? उनको करने की आवश्यकता ही नहीं है। नहीं, आप समझो, जब आपके पास औकात ही नहीं है सब्सक्राइब करने की, तो आप दूसरों को कैसे रोक सकते हो? And one more thing, when I go to outsiders, you can also apply if you have guts. Can't existing shareholders apply as a public? तो क्या गलत क्या है उसमें? हाँ, over there when they are existing shareholders, if they're applying through the, I would say the third point, as an outsider, the point is now there is no guarantee that their application will be selected and selected. इतना फर्क है। तो मत दो, वही लॉ कहना चाहता है ना, मत दो। किसने कहा वो दो? मत दो। बात ये है कि if 75% people are expecting that you can go to outside, मेजोरिटी में एक बात समझ मेरे भाई, तूने मोदी को वोट नहीं दिया, समझ। आपने मोदी सबको वोट नहीं दिया, ठीक है। अब मोदी सब जीएसटी लेके आ गए, और तो ये कहता है मैं क्यों फॉलो करूं, मैंने थोड़ी वोट दिया था। मेजोरिटी ही सत्य है। आप समझ रहे हो? जब मेजोरिटी किया तो तेरी इंडिविजुअल वोट की, अगर मेजोरिटी ने वोट किया कि हमको नहीं देना है, तो ये आप बाहर जा ही नहीं सकते। सीधी सी बात है ना भाई, ठीक है। So board meeting, they will prepare the scheme and they will issue an offer letter to all the existing equity shareholders. This is what the scheme we have proposed and whether you want to buy this or not. Now here some points are important. Time. So law make amendment आया, earlier there were 15 days. कितना दिन था? At least you have to give how many days? 15 and maximum 30. I think you might have done that in the right issue chapter. But now 15 word has been amended in 2021. It has become now what? 7 days. 7 days. यहाँ पे लिखा है all such letters. If you just click on over here 8, look at. Wait. Okay. If you come here, just a second. Not here. All right. It is written now that lesser number. So yes, number is now has become less. So instead of 15, now what should be read? 7. So now company can give minimum 7 days, maximum 30 days. ठीक है? One more point I want to tell you that yes, once existing shareholders are given this opportunity to give the first priority over the shares, so it is on them whether they have to apply or not, because ultimately cash will go out of the pocket. अरे हाँ है ना? पैसा तो जाएगा ही जाएगा. So it is on them whether they want to pay or not. What if they don't have cash? Can they transfer their right to some of their friends? For example, I was the existing shareholder and I got the offer, but I don't have money. But you are interested to buy this, so I told you that I got the offer letter, but I cannot do this. Are you interested? And you said yes, I'm interested. And you applied. You applied, and company rejected your application, stating that, "Bhai, tu kaun hai? I offered this to my existing shareholder. Who are you?" And then you said, "But your existing shareholders renounced thee." This word is very important. Renounced his right in my favor. So my point is, even if you are outsider, but the existing shareholder has transferred his right to apply in your favor, do you have right to apply for the right issue? Answer to that question is absolutely yes. You can do this. In fact, when you read this, look at over here. It is written that the offer of a sale shall be deemed to include a right exercisable by the person consent to the renounce the shares. Renounce is actually the word what is constituted after merging the two words. The first one is re and second one is announce. Re-announce. Company has announced to me, I am re-announcing to anyone to whom I approach. So answer to this question is yes, you have the right to go for the re-announce. I hope I'm clear to all of you. I hope I am clear to all of you. क्या बेटा मेरी बात समझ में आई यहाँ पे? So here I'm just concluding, my dear students, the right issue in detail, whatever provisions are there. So guys, in fact, I have completed subclause A and subclause C here. Now the main point is about this subclause B, which is nothing but the employee. Again, guys, when you're offering to the employees, are you going to the bahar wali? Yes, obviously, employees are not. देखो अभी आप समझ नहीं रहे हो. Employees are part of the internal organization, but they are not a part of internal ownership. आप समझ रहे हो? काम वाली अगर घर में काम करने के लिए आती है तो उसको हम घर वाली नहीं मान सकते. Employees are working in the organization, but वो घर वाली थोड़ी है. God, I don't know whether you are understanding this or not. वो पावर थोड़ी मिलता है उसको. So again, guys, when you are giving it to employees, you are introducing ownership to them. You are giving the status as good as like घर वाली. Yes, guys, what law says that you have to go for exactly consent rule. No, any general meeting you can call. You have to call the general meeting, or there is section 110 is there, postal ballot. Get the votes through posts. Get the votes through. Write a letter to all the shareholders. Ask a question. Give some options and tell them to take the appropriate votes. Return me back. तो वैसे भी एक provision है that we are going to learn under section 110, not as of now. In fact, you come here the chapter of the management and the administration here. भाई किधर गया? हाँ ये रहा, देखो आ जाओ 110 पे. देखो ये क्या लिखा है. तो ये बस वही चीज है कि वो सारे assumptions है जो आप कह रहे हो कि सिर्फ एजीएम ही होगा. अपनी जनरल मीटिंग कॉल करो, नहीं हो तो पोस्टल बैलेट में चले जाओ. मीटिंग बुलाने की आवश्यकता भी नहीं है. ठीक है. Okay, so students, am I clear till this? So guys, ample stock options, if they are asking you the question, the point is you have to pass the special resolution. So guys, again, ESOP is not a favor in the terms of discount. It is just favor in the terms of the better priority over others to get the shares. That's all. Remaining all the rights, liabilities, responsibilities, everything would remain as it is. Everything will remain as it is. Okay, am I clear? So guys, with this entire 62 I have done here. Yeah, however, this 62 has certain exceptions. That means even if you are issuing to the outsiders, you no need to pass the special resolution. That's what is called the exception. When I asking you, what are the exceptions to the rule of section 62? तो बात एक सीधी सी है. If you are going for other than existing one, you have to pass special resolution, whether to employees or whether to the outsiders. But what are the circumstances where you are approaching to the outsiders, but you don't require to pass the special resolution? So the first point what is written over here, and that is the convertible shares. क्या है? Convertible shares. Let me tell you which are convertible debentures actually, not shares. Okay, debentures, convertible debentures. Now, convertible debentures what are provided here under section subsection 3 and subsection 4. Look, if you look at over here, both the subsections are talking about what? Debentures, 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 debentures. Are you getting my point? So look, what does it mean? Suppose you have issued the debentures and now you want to convert the debentures into what? Shares. Debenture holders are not equity shareholders. So as soon as you are converting debentures into equity shares, isn't it you are issuing the share capital to the someone who is outside? Again, guys, debenture holders are not owners. So do we need to pass the special resolution? So here law says that no, you don't need to. How come? If these debentures had been issued, not only debenture, I also want to say, isn't it possible that you have taken the loan of 200 crores, suppose, and now you don't have money. So bank proposed, okay, you don't have money, man, I can understand. But the point is, you have to convert my loan to the equity shares. पॉसिबल तो दो बातें यहाँ पे की गई है कन्वर्टेबल डिबेंचर के बारे में भी बात की गई है कन्वर्टेबल लोन के बारे में भी बात की गई है बट द पॉइंट इज while converting these things you are inviting the new shareholders and law clearly says why new को आप नहीं ला सकते until and unless you have taken the consent of existing one तो लॉ ने ये कहा कि while taking or accepting such debentures not at the time of conversion while accepting such debentures while accepting such loan if you would have passed देखो सीधा लिखा है such an option have been approved before the issue of the debentures or raising the loan. So before taking the loan or before taking the debentures, if you have taken the approval by way of what? Then you no need to pass it again while converting these things. Why? Because why this thing is already approved long back. So when approval was already taken, you don't need to go for the again here. Even if it is not done this, sometimes it is the part of debt restructuring. Still you can go, still you can go. Look up, because if you see the subsection 3, पैराग्राफ में ये लिखा है कि स्पेशल रेजोल्यूशन सपोज टू बी पास्ड व्हाइल रेजिंग द लोन इसमें ये नहीं लिखा है कि कॉन्ट्रैक्ट मस्ट कंटेन द क्लॉज हाँ नहीं ये काफी बड़ी बात है भाई ये आर्गुमेंट में कोर्ट में कर सकते हो गड़बड़ नहीं होगी इंडियन कॉन्ट्रैक्ट एक्ट यहाँ पे एप्लीकेबल हो जाएगा मेरे भाई वो सीधे बात कहता है जब म्यूचुअल कंसेंट से तुम कोई भी कॉन्ट्रैक्चुअल टर्म वेरी करना चाहते हो तो तुम कर सकते हो कंपनी करना चाहती है कन्वर्जन ठीक है बोर्ड करना चाहती है ठीक है मतलब बैंक करना चाहती है ठीक है जाओ आगे क्या गलत है कंपनी को इश्यू नहीं है बैंक को इश्यू नहीं है भाई इसीलिए तो कहा कि लोन लेने से पहले क्या पास करना है एक सेकंड रुकिए नहीं ये तुम्हारा पॉइंट वैलिड है मुझे एक बार फिर से देखने दो रुको हाँ यू आर राइट बेटा आपका पॉइंट एकदम वैलिड है नॉट ओनली लोन बट वो ऑप्शन ऑफ कन्वर्जन मस्ट हैव टू बी अप्रूव्ड गॉट द पॉइंट तो देखो इसमें एक्सप्लेनेशन ये है कि ये ऑप्शन एग्रीमेंट में होना जरूरी नहीं है जो आपका बेसिक डाउट था एग्रीमेंट में हो या ना हो लेकिन हाँ शेयर होल्डर को आपने पहले पूछ लिया कि इन फ्यूचर इफ कंपनी वांट्स ना व्हाटएवर हैपेंड बिटवीन यू एंड बैंक इसको कोई लेना देना नहीं है आपने शेयर होल्डर्स को पहले से ही पूछ लिया था दैट इन फ्यूचर इफ आई कन्वर्ट दिस डिबेंचर्स टू इक्विटी शेयर्स और लोन टू इक्विटी शेयर्स यू शुडंट हैव एनी प्रॉब्लम and special resolution already taken so it is just like this already consent was taken then why you go to again दो बार क्यों आपको करना है भाई पहले ही आपने दे दिया तो खत्म हो गई बात यहाँ पे am I clear now but in this subsection 4 you don't need to go for even special resolution आपको यहाँ पे तो वो स्पेशल रेजोल्यूशन में भी नहीं जाना है because here it is talking about the debentures or the loan which had been obtained by the government, by the company. When government खुद ये बोलता that I want the equity shares, and now your question comes, but what about the consent of the shareholders? देखो गवर्नमेंट जब आपको ये कहता है कि आई वांट टू बिकम पार्टिसिपेंट इन योर कंपनी, दैट मींस गवर्नमेंट वांट्स टू कंट्रोल द कंपनी. According to the duties of the government, while reading the constitution, अगर हम बात करें, government can control anything in this country for the sake of national interest. Are you getting me? तो अगर देश के हित में गवर्नमेंट आपके कंपनी में कंट्रोल डालना चाहती है, आप कौन होते हो रोकने वाले? देश बड़ा है, आपकी कंपनी बड़ी. You must have heard about certain incidents like this, that you are occupying a land, suddenly the government discovers that your land has a lot of petroleum reservoirs. Petroleum reservoirs, like if you just dig it down, you will find a lot of quantity of the petrol. So government ने सीधा क्या किया ना, आपको पूछा कुछ नहीं. They offered you that we are going to give you 25 lakhs, vacate the land. And you said no, we haven't any contract, I don't want to sell. क्या ये चलेगा? बेटा आपको लैंड सरेंडर कर देनी ही पड़ेगी. हाँ, you can file the case for the compensation if you feel it's less. आपको लगे 25 lakhs is not sufficient, I want 50, that you can go to the court, but you can't file the case, no, no, I don't want to give. हाँ, if you have the evidences to prove that this land is captured not for the national interest but for to give some benefits to some private stakeholders, अगर ये एविडेंसेस है आपके पास, तो उसके डिसीजन को चैलेंज किया जा सकता है. बट दिख ही रहा है पेट्रोल निकला है, तो देश के हित में होना है भाई, तो नहीं कर सकते. सो व्हेन गवर्नमेंट वांट्स, right, that we want to convert your debenture, the loan what was financed by us, to the equity shares, you have to, and I'm telling you now the government will be the new shareholder. Do you agree with that? So even if the special resolution was not passed at the time of conversion, you do not have right to say it is the violation of section 62. आप ऐसा नहीं कह सकते. Okay guys, so do you know what, in the lights of like while explaining the points of the employee stock option, अगर हम बात करें, we have learned entire concept of the further issue of the share capital. But still my fundamental question remained unanswered, and that one is, what is the difference between the sweat equity shares and the stock, the employee stock option? वो तो भी मुझे पता है नहीं. Whatever we have learned so far, that was more of about what? Employee stock options. हाँ है ना? तो एक बात समझ में आई बेटा, एम्प्लॉय स्टॉक ऑप्शन फेवर तो है, बट इन व्हाट कॉन्टेक्स्ट इट इज द फेवर? जस्ट द प्रायोरिटी, यू आर गिवन द चांसेस above or prior to the others, that's all. But guys, SWAT equity shares ये प्रायोरिटी नहीं देता, ये रिवॉर्ड देता है. क्या देता है? रिवॉर्ड. For the SWAT, what you spread it for the company's interest, for the company's welfare. So I am telling you, SWAT equity shares is not available for all the employees. So, okay, answer me one question. Employee stock option may be available for all the employees if company wishes. Yes. But the SWAT equity shares is not available to all the employees. Only to those who have added some value in the company's growth. For example, you all are scientists and you invented the medicines of HIV/AIDS. And definitely, just because of your efforts, when company patentize these things, will company get the benefit or not? So you all scientists who are working day and night for the company, our company will reward you by issuing the SWAT equity shares. So देखो ऑब्जेक्ट दोनों के डिफरेंस है. In employee stock option, you are just given the priority, but over here just not a priority, आपको respect दी जा रही है. That I am giving you, I'm so much glad and happy, and I wish that the persons like you must be in my company's ownership as being the shareholders, and therefore I am giving these equity shares at discounted price. No matter my fair market value is 250 rupees, but I'm giving you at zero price. I'm giving you just at 10 rupees. Just imagine guys right now, market price is 250, I'm giving you 10,000 shares. तो उसकी वैल्यू कितनी है? 250 into 10,000. It is somewhere around 25 lakhs rupees. But I'm offering this at the zero price. So just by giving this 10,000 shares, I'm giving you the gift of 25 lakhs rupees, my dear students. According to the market value, you are now given the assets valued rupees 25 lakhs. तो दोनों के ऑब्जेक्ट्स डिफरेंट है. आप ये समझो, एक में रिस्पेक्ट देने की बात है और दूसरे में सिर्फ प्रायोरिटी देने की बात है. एक में सम्मान है, ऑनर है. However, again, guys, whenever I speak about the sweat equity shares, no doubt discount भी दे सकते हो. But again, you are inviting outsiders. बाहर वाले को इनवाइट कर रहे हो, तो घर वाले को. Exactly. So, guys, the first and fundamental things is what is the common between these two? If you want to issue the sweat equity shares, you can't until and unless you have passed special resolution of. भाई इसीलिए तो उनको ओनर की तरह माना गया है. ओनर. और ये जरूरी है भाई. अब तुम समझो यार, पब्लिक का पैसा पैसा आते ही लोगों की बुद्धि भ्रष्ट हो जाती है. ये जरूरी है, आवश्यक है. ये स्ट्रिक्टनेस चाहिए ही चाहिए आपको. क्लियर? Now, now you see, once the fundamental thing is clear, now let's see that what kind of questions are possible under this section 54. So first question is, right now guys, these kinds of questions are possible. Pahla, who can get sweat equity shares? Who can get the sweat equity shares? That's the first question. Second question is how to issue. So that's already I have explained you how to call the general meeting and you how to pass what? Special resolution. Third is maximum tenure. Maximum tenure. Not maximum tenure, maximum limit. Maximum limit. Maximum limit. Other requirements. Other requirements. Other requirements. Clear? इतना के आंसर दे दो, आपकी पूरी शॉर्ट नोट तैयार हो जाएगी. Few answers you will get from the provisions, some answers you will get from the rules what is synced with the provision. ठीक है, तो शुरू करें बच्चा. तो my first question is who can get it? All right. So first is the employees plus directors can get it. Employees plus directors can get this. Now another question is what is the meaning or definition of employees? ये आपका पहला क्वेश्चन है. Employees का मतलब क्या हुआ? Do you really think that all the employees can get this? Do you really think? Answer is no. The first thing what I want to tell you over here is you should be whole-time employees. So temporary employees are full-time employees rather I would say. So okay, let me just read over here so that you can get the answer of the few questions easily. लिखने से अच्छा हम यहीं पे से ले लें तो आपको थोड़ा कॉन्फिडेंस भी आ जाएगा. हम जाते हैं 54 पे. Let's come down to sweat equity shares. So here look at क्या लिखा हुआ है यहाँ पे. Notwithstanding anything contained in section 53 means whatever prohibitions are provided in section 53 would not apply here. A company may issue the sweat equity shares of a class or the shares of the class already issued if the following conditions are satisfied. First of all आपको क्या करना है भाई? ठीक है. The resolution must specify current market price, but this current market price you have to understand as the fair market price, not the something what is getting driven in the market. And what consideration you are receiving. So guys, you tell me, market price minus consideration, the difference automatically should constitute as what? वही चीज वो मैंने कल भी पढ़ा दिया था. If any in the class of the classes of the directors to whom such shares are to be issued. So guys, while you are issuing the resolution, definitely you have to give the notice to all the shareholders. You have to tell them, okay, bhai, this is what the market price, this is what we are offering. So automatically they have understood the difference is nothing but the gift. आ रहा है ना? All right. This is omitted. This is omitted. Now omitted means deleted, तो उसको हमको पढ़ने की आवश्यकता नहीं है. तो why? Okay, what was the provision? पहले ये था कि employee की definition में employee means those employee who has completed not less than. अब ये डिलीट हो गया है. अब इसका मतलब क्या हुआ? Just your employee, even if you have worked for the 6 months in the company, but you have contributed very considerable in the growth of the company, you deserve to get this. तो आज वो 1 साल वाली रिक्वायरमेंट की जरूरत नहीं. बेटा समझ में आई बात? Where the equity shares of the company are listed on the stock exchange, the SWAT equity shares are issued in accordance with the SEBI guidelines, and if they are not listed, it will be issued according to the rules of the central government what is prescribed here. अब देखो ये भी गेम हो गया. लिस्टेड कंपनी, आई टोल्ड यू, कंपनीज एक्ट नहीं, सेबी में चले जाओ, और अगर आप लिस्टेड नहीं हो तो ऑप्शन दिया है आप, ठीक है. रूल्स में ही बहुत सारी चीजें हैं. Rights and limitations would be as it is just like the other equity shareholders. Am I clear? So we assume that the company is not listed in the stock exchange, it is unlisted. What are the rules? तो देखो बड़ा over and above that आपको इतना सारा और पढ़ना पड़ेगा. Did you see in the entire act लिमिट के बारे में कुछ नहीं कहा गया? अरे बोलो भाई. एम्प्लॉयज की डेफिनेशन के बारे में कुछ नहीं कहा गया. Value addition, because I told you you must have added some value to the growth of the company. What do you mean by value addition? उसके बारे में कुछ नहीं कहा गया. So law is silent, but rules provide all the details. So that means I am saying the preparation of the CA inter includes what? Act as well as rules. ठीक है. तो without wasting much time, सीधा हम आगे जाते हैं. तो guys, a company other than a listed company. Why it is written other than a listed company? Because for the listed company we have the separate rules as specified by the. So whatever we are discussing, guys, it is applicable to unlisted company. So guys, first point अब हम quickly करेंगे. Employee का मतलब क्या हुआ? तो सबसे पहला बात लिखा है permanent. वो अभी मैंने पढ़ा दिया. तो part time employees are not acceptable. This word is omitted, and what had been omitted, I think you know that. Is it compulsory that they should be Indian employees? What if my company's employees are working outside India? Then they are also included. It is written that doesn't matter whether they are working in India or they are outside India. A director of the company. But ये काफी गजब चीज है. In order to make you confused, I can ask you the question like this: that there is a director but a part-time director. Does he deserve to get the certificate shares? Sparsh? हाँ तो तेरा आंसर क्या है भाई? क्या पार्ट टाइम डायरेक्टर को स्वाइट इक्विटी मिलने चाहिए? बेटा एक बात समझो, ये जो रिस्ट्रिक्शन लिखा है ना परमानेंट, समझ रहे हो? परमानेंट, टेम्पररी वाले नहीं चलेंगे आप. वो एम्प्लॉइज के लिए है, डायरेक्टर्स के लिए नहीं. So guys, answer to this question is if the director is temporary or part-time, he deserves to get what? Sweat equity shares. Clear? ठीक है. So not only to that, any employee or the director who is working in the subsidiary of this company or the holding of this company, they also deserve to get 54. So just imagine guys, क्वेश्चन कितनी बढ़िया बन सकती है इस पॉइंट पे. अगर आपने ठीक से नहीं पढ़ा बेटा तो देखो कैसे पंगे हो सकते हैं. द पॉइंट इज आई एम द कंपनी राइट नाउ, ठीक है. और हुआ क्या, आई वांट टू इश्यू द स्वेट इक्विटी शेयर्स ऑफ माय होल्डिंग कंपनीज एम्प्लॉइज. सो अलाउड और नॉट अलाउड? तो सीधी सी बात है, if they are employees according to section 54 allowed, if they are not employees according to section 54 they are not allowed. but यहाँ पे तो सीधी बात लिखी है, any employee of the subsidiary or any employee of holding company. सब्सिडरी के एम्प्लॉइज को भी दे सकता हो. बेटा इस पैराग्राफ में रिश्तेदारी निभाई है कानून ने, फैमिलीहुड, मतलब मेरे फैमिली में जितने लोग हो उन सबको दे सकता हूँ. So guys, it's not necessarily to be restricted only to the extent of द कंपनी, ठीक है। तो ये ध्यान रखिए। देन डेफिनेशन ऑफ द वैल्यू एडिशन इज गिवन, आई डोंट वांट टू टीच दैट, इज सेल्फ एक्सप्लेनेटरी है। समथिंग यू हैव टू हैव एडेड इन द कंपनीज ग्रोथ, economically, talent wise, design wise, some intellectual rights wise, like you invented the things in such a way so that company can apply for the copyrights or company can apply for the patent rights. So if you have helped the company to get the patent rights, congratulations, you are here as value additioner, value adder. Okay. So what it contains, everything is there. Directly come here. So these all are the details that resolutions what you are going to pass. So notice contains what? तो मैंने आपको बता दिया पहले से. Class of the employees and consideration what you are going to receive, the market price, everything you have to provide here. Now the rule number 4 is telling you something about the maximum लिमिट बियॉन्ड विच द कंपनी इज नॉट अलाउड। तो देखो यहाँ पे दो लिमिट्स आपको समझनी है। जब मैं बात करूँ सब रूल 4 की, ठीक है, तो सब रूल 4 में दो बातें समझनी लिमिट में। लिमिट कैन बी क्लासिफाइड इनटू, बोलो भाई, लिमिट हियर कैन बी क्लासिफाइड इनटू टू पार्ट्स। फर्स्ट इट सेज वन टाइम लिमिट and second is known as overall limit, that in 1 year how much you can go. One time means like once in a year, that's what I want to say. Are you getting my point? And overall means एग्जैक्टली ओवरऑल आप कितना कर सकते हो, वो जो भी नंबर आए उससे आगे नहीं जाना चाहिए आप समझ रहे हो। तो गाइस वंस इन ईयर इट इज रिटन 15%, but overall it should not go for beyond 25%. Now 15% of what it is written that the company shall not issue the sweat equity shares for more than 15% of the existing paid up share capital in a year, or the shares of the issue value of rupees 5 crores, whichever is what higher. So 15% of the paid up share capital or 5 crores, whichever is higher, in one shot, in 1 year you can go. But look at this provided। अब देखो आपको एक बात बता दो, यहाँ पे ऐसे वर्ड्स आपने लॉ में बहुत बार देखे होंगे। टैक्सेशन थोड़ा हुआ नहीं हुआ, थोड़ा जीएसटी हो गया होगा, तो कभी इस पैराग्राफ ऐसा पड़ा प्रोवाइडेड, ये क्या होता है, ये प्रोवाइडेड वाले पैराग्राफ को क्या कहते हैं, ऐसे टर्न मारते हैं, ऊपर कुछ लिखा है, एक छोटी सी विंडो ओपन कर देते हैं, है ना, कि हाँ हर साल 15% तो कर सकते, लेकिन ऐसा हुआ तो नहीं कर सकते। So guys, provided जब भी शुरू होता है लॉ में, उसको exceptions to the above provision माने जाते हैं, और इसीलिए this paragraph has a specific name. Anyone has any idea इसको क्या कहते हैं? जब आप लॉ की प्रैक्टिस करेंगे ना तो ये बोलना पड़ेगा कि पैराग्राफ क्या है, इलिस्ट्रेशन है, एक्सप्लेनेशन है, ये है क्या, डेफिनेशन है, वो बताना पड़ेगा ना कोर्ट को। Guys, wherever the sentence in the paragraph starts with the word provided, it is known as proviso. ध्यान रखिएगा, उसको proviso के नाम से जानते हैं, proviso, ठीक है। So however the shares in the company shall not exceed how much, 25% of the paid up share capital of the company at any time, at any time, at any time. Am I clear to all of you? So sweat equity shares is what, the gift to the directors, yes or no? So that would be added as the additional remuneration in the directors or employees or salary or the remuneration. तो ये सारी कुछ आगे बातें लिखी। Yes, you have to get on the valuation report also, so that the shareholders may come to know that how much favor is given, how much favor is given. Clear? All right. तो इतना ही आपको पढ़ना है, बाकी नहीं पढ़ना है, because whatever book I opened over there, it's professional. तो आपके एग्जाम के लिए इतना काम में आ गया। चलो बेटा, हाउ टू इश्यू स्पेशल रेजोल्यूशन, मैक्सिमम लिमिट, हु कैन गेट दी, सो वेदर ही इज वर्किंग इन आउट लाइक इंडिया और आउटसाइड इंडिया, पूरा हमने पढ़ लिया यहाँ पे। इन द other requirements I forgot to tell you one thing, it is Hey, what happens is like you are given the sweat equity shares right now. In my example, you see, you are rewarded with 25 lakhs rupees value. Today you are given the shares, tomorrow you sold it. Exactly, that's what. So you can't sell it immediately. Law ने कहा कि once these shares are issued, there's a lock-in period. क्या है? Lock-in period, not you have to hold it for the at least 3 years. Exactly. आपको ये shares अपने पास कम से कम कितने बच्चा not transferable for a period of 3 years from the date of allotment. ठीक है, so this is nothing but the lock-in period. चलो बच्चों, am I clear to all of you? अरे बोलो भाई. तो this kinds of things can they can also ask in the exam as MCQ also. So students, this is what is हमने 54 खत्म कर दिया यहाँ पे. I hope 54 with the explanation to 62 सब समझ में आया होगा. बोलो भाई. ठीक है.